Yeah, I know, I did see yours. I know we did get it, yeah. Yeah.
Well, do I put my daughter's name?
Oh, if you, I don't know if there's a way to print it or anything, you could do it.
We have a printer right here, yeah, yeah. Wait, is it an indictment or a familial unit issue?
It's like medical kidnapping, so. Family.
Okay, that's family, interference with family would be right, and that's this form that we have sitting right here. Yeah.
Yeah, because at the time, my son hadn't been criminally convicted, so it's not going to.
Okay,
He's
convicted
severely
now?
autistic, he's like a toddler.
Yeah.
He was DHS retaliated and filed a fifth-degree sexual assault, but it was dropped with a Rule 21 with the NAACP attorney.
okay. All right,
It was just a whole thing, we had to
Hey,
wait
can-
for an attorney.
Before you do that,
yeah.
can you go over how they fill this out?
Yeah, yeah.
Yeah.
Yeah, so I'm live right now on TikTok, YouTube, and Facebook. This is the first town hall meeting that we're having, guys. Thank you for joining me, and let me close this door before, because I like to be loud. So, you guys, I'm not dealing anything with you guys, all right? I'm gonna be talking with everybody out here. You guys, you can listen in, you can hear the questions. I'm not gonna be responding to any questions from any of you right now. You guys can ask your questions if you want. We'll come back and I'll try to answer them sometime later, but I'm gonna pay attention to the people that are here with me. This is the start of this tour, so be watching for us to come to your city because we're gonna be doing these about every 2 days, it looks like right now. So, as we move across, we picked up all the affidavits from the first site. We have them right here behind me. I think it's pretty decent numbers, but we'll see where we're at. We're gonna make the 500,000, guys. I'm pretty confident we're gonna make the 500,000. So, thank you guys for joining me. I'm gonna go over here. So, thank you guys for coming out. My name's Tanawah M, and so I'm a national civil rights advocate and litigator, and we are working on a couple very, very, very big cases. One in particular that I know about half of you or 3/4 of you here are familial unit and interference with the familial unit. But I want to explain how the indictment issue bridges and how it relates to the familial unit, because it's very important that people understand this particular issue. So, I think we can all agree that the Constitution of the United States of America is the overarching requirements that every state must follow, right? I think that everybody understands that what it says is the supreme law of the land, and that states don't have the right to be able to create their own laws and then substitute those laws for what the Constitution says. That would clearly be something contrary to what we all believe, right? So when a state does do that, when they do create a law and then they substitute it for what the Constitution says and then they go out and enforce it, now a crime has been committed, right? And this is a serious crime, right? As prescribed by law, it's actually punishable by death, right? Because it derives from a crime known as sedition, which is the basis of treason. And so I'm not saying that we need to do that, but what I am saying is what I'm trying to do is I'm trying to draw a line in the sand, okay? And I'm trying to say to these public officials that what you guys are doing is clearly unlawful. Right? It's contrary to what the people's fundamental rights are. It's unconstitutional, and as a result, they need to make a decision which side of the law they want to be on. Because once I make them aware that they're committing crimes, they really have a choice at that point in time. They can continue to do it, in which case, well, we're going to make sure that you are held accountable for your knowingly and willingly and intentional criminal acts against the people of the United States. Or two, they can return to established rule of law and we'll work together to fix the problem. So when it comes to a violation of a constitutional right, there's what's known as a facial constitutional right or a violation, and there's an incorporated violation. So the difference is this, is that a facial constitutional violation is a violation of a right that's specifically enumerated within the Constitution of the United States. It's actually written right there. You can see it within the Bill of Rights. And so when you have a breach of that sort, well, there's no question as to whether or not, they violated the Constitution. Now, an incorporated right is a right that was found to exist. It's not written in the Constitution, it's not written in the Bill of Rights, but it was found to exist. And the fact that it was found to exist means that it's still protected, but you can't fight it from the same way because different courts act differently, and it's not there for all to see. So the reason why I'm using this indictment issue as opposed to the familial unit issue is because Clause 1 of Amendment 5, that's certainly part of the Constitution, right? It was adopted and ratified by the people on December 15th, 1791. In all intents and purposes, there's no denying or arguing that the Bill of Rights is part of the Constitution. So when Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, that's an enumerated right to not be held to answer, not be arrested and held without an indictment by a grand jury first. That's what it says. So when these states, for instance, the state of Washington, which is the primary respondent in our litigation, the state of Washington says no grand jury shall be drawn or summoned in any county in their particular constitution, the inferior state constitution. So why is it that the United States Constitution says you have to have an indictment by a grand jury, but the state of Washington says we're not going to do a grand jury? Now you have an issue of conflicting laws between an inferior state law and the United States Constitution, and now you have what's known as a supremacy issue, right? Now we have to determine which law is supreme, and once we determine that, then we can figure out how we're going to move forward. So right now today, there are 42 states that do not conduct a grand jury, including the state of Minnesota here. And these are states that are acting in direct willful defiance of the established procedures and processes codified in the Constitution of the United States of America. That's a pretty big deal. It means that there's more than 700,000 people currently in prison here in America on direct facial constitutional violations. Direct facial constitution. And that means that their judgment is void. It doesn't even exist because it derives from an arrest that is in direct conflict and violation of the Constitution, which means that the judgment that they have, whether they pled guilty, whether they went through a trial, it doesn't matter because it's all fruit of the poisonous tree. It all derives from an unconstitutional arrest. So any act at the beginning cannot become constitutional over time or by subsequent legislation. So the moment that the state decided that it was not going to do what is very specifically enumerated within 10 pages of law, then what they're producing is unconstitutional. There's no arguing that, there's no denying that, and as a result, now we need to bring in preemption and determine which law is supreme. Once we determine that, then we can figure out how we're going to address the issue. So that's the indictment issue. That's the main argument that we're bringing forward, and that we're going to easily win. I mean, there's no doubt about that, because I'll come back to that in a moment, but we're going to win. Now, the family issue is a little bit different because the familial unit, nowhere in the Constitution of the United States does it say anything about your family being protected, right? And my issue with that is that the protection of the family should have been the first act of our government, not the last act, right? I mean, a family could survive without a nation, but a nation cannot survive without the family. And the destruction, breakdown of the familial unit that we're doing right now, so we can go out and invest in for-profit companies that build and operate prisons, is absolutely destroying our country. Because every single child that we take from the love and care of their family, that child grows up and has an 80% likelihood of going to prison over their lifetime. So now we have a system that's benefiting from the very people and trauma that they're inflicting upon your children, right? Because that child doesn't get the love that they need, and as a result, they don't have the tools that's necessary to be able to become a part of and a member of society, living within the parameters that society has created. So, I know that I'm kind of starting at the end with the prisoners, and a lot of people have a problem with me doing that. But what I like to say is that every single prisoner is someone's child. Every single one of them is someone's child. And that mother or father, they love that child a lot, right? Even if that child has done wrong. And so, but when we look at the trauma that the system is inflicting upon these people, generational trauma, we're not addressing and resolving this issue. We've seen an 800% increase in the prison population in 30 years. 800% increase. This is an unsustainable track that we're on right now. We've got $600 billion a year that goes to these prison systems, right? This is not, it's not conducive with a free society. It's not conducive with a just system. And it's certainly not consistent with, I think, what the American people believe in, because when they actually understand what is going on and how these agents are violating the rights, starting from the very beginning with these children, by removing them from the love and care of the family, it's producing a product that they are financially benefiting from, and we're not going to permit this anymore. We're not going to permit it anymore. So I know I'm starting with the end, but what I hope to do over the next month of going out and doing these town hall meetings is I hope to get people to understand how the monster started, right? Because the monster is what we look at. But what we need to do is we need to start from the beginning and say, what created that monster? And let's bring that person back to that point. So what I like to say is that we've got to stop looking at what people do. Because when we look at what they do, all we see is that monster that needs to pay for the things they've done. And that creates this vengeance-based system that we have in place today, right? But when we look at what's done to them long before the crime, as a child, as a husband, as a mother, then we see that something tragic happened to this person and it changed the trajectory of their life. And now we want to help them, now we want to heal them, and now we can see the reason why they've done the things they've done. When we rebuild the person back from the beginning and we deal with that, now we can have compassion for this person or this child that ultimately has turned into something that society has deemed a criminal and a monster. And so what we have many nations that we can look at as examples. Sweden, for instance, Sweden is getting ready to shut down their final prison right now. Getting ready to shut it down because they chose to heal their people. In Sweden, if you're a serial killer, you go out to work during the day. You come home to a house. You wear normal clothes because the whole point is they want to make you into a person. Because the reason why people hurt another human being is because they don't have respect for life. But that respect for life derives from your own respect for self. So if we can get a person to respect their own selves by loving them and caring about them and letting them know that they are worth love and compassion, then we can bring the person back, and then the monster doesn't exist. And I'm telling you, Sweden has one of the lowest racism rates that there is in the whole world, and they're shutting down the last prison right now as we speak because they don't have criminals. They don't have monsters there anymore. We're the only nation left in the world that chose a punitive-based justice system. We're taking hurting people, we're putting them into hurtful situations, and then we're expecting them to get healed and happy, and that's not how it works, right? So we need to look at these people as people, and we need to say, what happened to you, and how can we help you be happy? So, another great example is the nation of Israel. The nation of Israel has a community known as the kibbutza. And if you're convicted of a violent crime within the nation of Israel, they will actually sentence you to go and live within the kibbutza. That's your punishment. Go, because this community is so peaceful, with no record of homicide in its history, that these people actually learn how to live peacefully because the environment that you're in dictates what you learn. If a mother and a father, if they create an abusive environment because they're abusive people, they're going to produce abusive children. That's what's going to happen, right? Because the children are a product of the environment that they're raised in. Same thing with a man. A man is a product of the environment that they live in. So if our leaders are criminals, right, and they're embezzling money or they're flying to Epstein Island or whatever it might be, then we can expect that the people are going to follow them in their criminality. So the way that we're trying to solve the issue of criminality today, where we go out and arrest the people for the crimes they commit, it's never going to work. That's why we've had an 800% increase in the prison population in 30 years. That's why we have 16 times more prisoners than the next closest industrialized nation. That's why we have 5% of the world's human population, but 26% of the world's prison population is because we have criminals that lead us. So the way that we have to deal with criminality is from the top down. That's why I'm going to the source of the problem, which is the United States Supreme Court, and I want them to own up to their criminality. And if they don't, then we will make sure that America knows the criminals that they truly are, the traitors that they are, the refusal to recognize and enforce the body of laws, that their institution was created and established to protect, defend, and preserve. We're going to let the whole world know that that's the situation. And so this case that we had, we're at the United States Supreme Court. And yes, we are bringing indictments as the primary mechanism because it's a facial constitutional violation. We have right here in these bins, we have about 100,000 affidavits from across the country here, right? So we have about 100,000 right now. I have 8 more sites to go and pick up from these consolidation points. Our goal is 500,000 of these. And when I return to Washington, D.C. in 40 days with these affidavits, we're going to go first to the FBI and ask them if they want to work with me and empower me to deal with these crimes. And if they don't, then we're going to take them over to the Supreme Court and we're going to say, what do you want to do about this? Because these are crimes that are being committed by your agents, under your watch, under your authority, and you can either, one, take action to address the crimes that are being committed by your agents, the judges, or you could tell the American people that you will not enforce the law, you will not protect them, you will not defend the Constitution of the United States, and then I would suggest that they go ahead and shut their lights off and head on home because they no longer have a court, because the only reason why they exist is because of the Constitution of the United States of America. If they don't have the power or the courage, the fortitude, or the honor to protect and defend the Constitution of the United States, then by their failure to take action, they will have destroyed their institution. Because the only reason why the Supreme Court of the United States exists is because of Article 3. So if they're not willing to defend Article 3, assert their supremacy, and make their agents obey the very laws that they must obey, then they no longer have an institution, right? That's why the court is going to take action on this. We've got plenty of indication of it. Justice Gorsuch is going around the country, and he's talking about everything that I'm talking about, and he agrees. So, yes, we are bringing an indictment issue, but let me just say that the heart of our argument is not just prisoners. The heart of our argument comes from in Article 3, Section 2, our issue. So what's getting us in the door to be argued is the Amendment 5 here. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Your son was arrested. He was held to answer for a felony without an indictment by a grand jury. Therefore, his arrest is unconstitutional. There's nothing that they can do to change that or make it become constitutional. Even if he pleads guilty in a week, it doesn't matter because the arrest is unconstitutional. Therefore, the plea bargain would derive from the unconstitutional arrest. Everything that's happening to him as of this moment is all an illusion. It's all just an illusion because everything that they do from this moment forward derives from that unconstitutional arrest. If they don't follow the rules and the constitutional parameters, what they're producing is unconstitutional. And there's no right to self-defense for a public official. No public official can say, oh, well, we broke the law, we violated the Constitution for this reason. The moment that there's a breach of constitutional violation, everything from that moment forward is all unconstitutional. It's all fruit of the poisonous tree because it all derives from an unconstitutional act. Right will produce right, wrong will produce wrong. Therefore, any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. So we're using indictments to get in to be heard. 700,000 people currently in prison across America on direct facial constitutional violations. And let me go ahead and say right now, especially for all of you here as well, I'm not advocating for the release of dangerous people. I'm not saying at all, don't get me wrong at all. But what I am saying is that we got to follow the rules. And if we don't follow the rules, then what you're doing is unlawful and it's unconstitutional. So the law is a double-edged sword. It cuts both directions. It doesn't just cut to the criminal. It also cuts to those attempting to adjudicate the criminality. And so if government breaks the law, it still is a crime. It still is unlawful, right? And so we have to say that this is, in Latin, it's known as dura lex sed lex. The law may be hard, but it's a law, okay? It's a law. And we're not going to bend on the law because the purpose of the Constitution is to establish rights and limit powers. People have rights, government has powers. The government's powers are specifically limited in order to preserve and protect the individual liberty of the people. So in some cases, state powers are limited. In other cases, federal government's powers are limited. In more cases, both governments' powers are limited, but they're all limited in order to preserve and protect the individual liberties of the people. And so this is very, very important because those people that don't even realize that they can be arrested at any moment for an arbitrary, capricious information or allegation from a public official, and they will not go through a proceeding with a neutral, unbiased decision maker to review the state's case, which is what the grand jury is there to do. Absent that neutral, unbiased decision maker, now you have a prosecutor who represents the accuser, right? And who is also on the exact same side as the judge, and they're making a decision as to your son's future. Where is the neutral, unbiased decision maker? Why is your son sitting in an institution where he hasn't been found guilty of anything yet, but yet he's sitting in jail and he's been there for how long? A year and a half, you said?
He's out. He's mentally incompetent. So he's bad.
Yeah. So nonetheless, I mean, and he's still under guardianship in the mental incapacitation, right? But what I am saying is that we're not going to release dangerous people. I would never, ever, I'm not an abolitionist by any stretch. I know that we have a system. We have dangerous people that live in our country. I don't want dangerous people out amongst the people, but we need to know who is or is not a danger. We need that legitimately known, because most criminologists across the world agree that only about 4% of our current prison population is a danger to society. That's the top criminologists in the world. 78% of people in prison never hurt anyone but themselves. Drug offenses, right? That's not a dangerous person. That's a hurting person, right? And the rest between 78 to 96, that's property offenses, theft and things of that sort. That's not dangerous behavior, that's aberrant behavior, right? And you treat aberrant behavior much differently than you do dangerous behavior. Dangerous people you do need to protect from society, right? We do need prisons. We have a system that if it works properly, I think that innocents would not suffer. But it has to it has to function properly. So, the aberrant behavior, that's corrected by leading people, right? That's corrected by being a good leader. That's corrected by being a good parent. That's, we can lead people in a good direction just by leading them, not leading them toward criminality. So before we could deal with the criminality of people, we got to start with the criminality of leadership of our country. So the Supreme Court of the United States is going to have to decide, do you want to be a criminal? And if you do, continue to do what you're doing. We'll continue down that path, right? In which case, I think that they know what the result's going to be, right? I think they know what the result's going to be. But if they don't want to be a criminal, then they can return to established rule of law. They can mitigate their culpability within the criminal conspiracy that I've shown exists across 42 states as of this moment. And the way that they do that is by notifying their co-conspirators that they will no longer participate in the criminal conspiracy. That's the only way, Supreme Court, that you can mitigate your culpability in this criminal conspiracy. No other way. Read the law. You must notify your co-conspirators of your intent to no longer participate. So if your co-conspirators are the judges across this country, across the states, then you better let those state judges know that you are no longer going to permit them to continue to break the law, primarily the Constitution of the United States of America. So we have an indictment issue, pretty serious issue, but now the heart of our argument is Article 3. Article 3 right here. So here's the Constitution. Anybody wants to read it here? Here's Amendment 5. Anybody? The highlighted area, that's Amendment 5. Okay? So this is Article, here's Article 3. This is our argument. What's in highlighted there? What Article 3 says, it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. And then it goes on to say that in all other cases of equity in law, the court shall have appellate jurisdiction. So what does that mean? Original jurisdiction means the court to act first. It's the original court. Original jurisdiction. So the original court is the court that must act first. No other court in the country can act before the court that has original jurisdiction. Appellate jurisdiction is the court that you go to last. That's court of last resort, right? So you appeal to that court. So it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Okay? So if a state is a party in a cause, the United States Supreme Court has original jurisdiction. It means that it's the court to act first. No other court in the country can act before the court of original jurisdiction. Now, there's very, very specific reasons why it says that. Now, we all know that Supreme Court is a court of last resort. We know that they're an appellate court. You appeal to the Supreme Court, the court you go to last. After all other courts fail and all other opportunities fail, you go to that court last, right? We're all very, very familiar with the Supreme Court of the United States' appellate jurisdiction. We're not familiar with its original jurisdiction because it hasn't been invoked since 1890. Hasn't been invoked. So this is a forgotten thing that's happened here. And we are going to Supreme Court under its original jurisdiction, invoking original jurisdiction, saying you have a constitutional obligation to oversee this case that we have. We're not asking you, we're telling you. It's the law. You must do it. And if you don't do it, then you are telling the people of the United States that you're not going to follow the Constitution once again. So when it comes to a constitutional obligation, constitutional obligations are non-discretionary and they're non-delegatable. You cannot use your discretion to break a constitutional law, right? Or an obligation. So if the Constitution says Supreme Court of the United States, you are the court of original jurisdiction, they can't delegate that to another court, right? They can't say, oh, well, we're gonna have the district court do it, because what that would do is that would be amending the Constitution in a manner other than the way in which the Constitution must be amended. Constitution can only be changed by the unauthentic act of people. That's in Article 5. You can read that. So Article 5 tells you the exact way that the Constitution can be changed, and it cannot be changed by the judicial branch because judges don't make law. Judges don't legislate. You cannot legislate from the bench. We all know that, right? So if the Supreme Court of the United States says, oh, well, we don't really like that, that's going to be difficult for us, or that's going to be burdensome, well, great. Present your case to the people of the United States and get the people of the United States to amend the Constitution in a lawful manner. And until that happens, what you're doing is unlawful and unconstitutional. And once again, a maximum law is any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. Doesn't matter how long this has been going on, it's still wrong. It still is unconstitutional, which means that everything they're doing is unconstitutional. So, and discretion, we believe that the Supreme Court of the United States is a court of discretion. The discretion came in. Now, discretion means that they have the ability to pick and choose which cases they want to hear or not hear, right? So the Supreme Court of the United States, there's somewhere around 70 million lawsuits every single year that are filed here in America, right? Supreme Court of the United States sees something like 7,000. So like 0.1% of the lawsuits that are filed here in America make it to that court, right? That actually get heard. It's not 7,000. It's I think 700 maybe. Anyway, they don't hear very much. It's less than it's 0.1% of the cases every year that actually get heard by that court because they say, oh well, we can pick and choose which case we want to hear or not hear because they can apply their discretion. Now, discretion can never be used with regard to a constitutional obligation because the Constitution is a law that created an obligation. And that obligation said to the Supreme Court, you got to hear this case, right? If a state is a party, you got to hear it. That's an obligation created by that is a constitutional obligation. So if they could use their discretion, then that would mean that they could use their discretion to break the law. And the Supreme Court has long litigated that you can never, ever use discretion with regard to one's obligations. Obligations must be performed because if you could, then that would mean that you could use your discretion to break the law. And that means the judge could say, well, it's okay for me to kill this person even though he's innocent, right? Or it's okay for me to deny you your right to be able to testify, and it's okay for me to deny you your right to have a jury trial. All these things that we know we have the right to, we have the right because the judges have the obligation to ensure that they're provided. And if the judge uses their discretion abusively to not give us what the Constitution says that we are entitled to, that's a constitutional violation, right? Same thing, Supreme Court. It's no different for them. But what happened was that in 1925, the United States Congress came out in the Judicial Reform Act and said, yep, the Supreme Court of the United States is now a court of discretion. All the state Supreme Courts are all now courts of discretion. Meaning they can pick and choose which case they want to hear or not hear. Now, even acts of Congress must comply with the Constitution. If acts of Congress don't comply with the Constitution, that would make them unconstitutional. So if the Constitution says that in all cases in which a state shall be party, Supreme Court has original jurisdiction, then that means that in order for the 1925 Judicial Reform Act to be constitutional and for the court to have discretion, a state can't be named a party. Because if the state is named a party, the United States Congress says, oh, they can use their discretion on that, then that would make that law unconstitutional. It would be because it's in violation of the Constitution. There's one way to change the Constitution of the United States, and it must be done by an authentic act of the people, right? So once 2/3 of both House and Senate vote on an amendment to the Constitution, then it goes out to the states, and once 3/4 of the states pass it through suffrage, through vote, once 3/4 of the states pass it, then it becomes part of the Constitution in all intents and purposes. And I'm going to tell you guys, the Constitution doesn't get changed very often. There's been more than 90,000 proposed amendments to the Constitution. We've had 27. 27. So it's not something that happens very, very often. You know, I don't know when in my lifetime an amendment's ever been ratified, but it doesn't happen very often. Not only that, but the Constitution is sitting in trust in the archives. So it's not like LII where you can go out to Cornell University and they can, make a couple changes to the words here and there. Oh no, that Constitution is sitting in trust in Washington, D.C., in archive. It doesn't get changed. We can go there at any point in time. And it even says right on the side of the building that our faith is entrusted within this building. Because what the American people believe in is that Constitution of the United States, and it does not get changed. They can't hide the words. They can't change the words because it's publicly available for us all to see. So we're starting with the indictment issue. Now the family issue. In 1984, the United States Supreme Court came out and said in a case called Roberts versus United States that you have the right to intimate association, right? Intimate association. And intimate association is that you have the right to have an intimate familial relationship with your child, and your child has the right to have an intimate familial relationship with you without governmental interference, right? And they found that it existed under the First Amendment. And that's very, very important, the First Amendment. Because the First Amendment are all the God-given rights. Everything after that is a civil right, but all the first are all the God-given rights. Now, a lot of people don't understand that or are confused about that because they say, well, I have the God-given right to have a gun. No, you don't, right? God didn't create the gun. Man created the gun. What God did give you is he gave you the absolute right to defend yourself, absolutely. But the way in which you choose to defend yourself became a notion of right or wrong that our society chose to protect under the Second Amendment. So the First Amendment are all freedoms. You have the freedom to speak. You have the freedom of religion. You have the freedom of press. These are freedoms because God allows you to speak. And until the day you're called home, you have the freedom to continue to speak. Therefore, you have the freedom of speech. You have the freedom of religion because you have the right to be able to develop your own morality and conscience and faith, and no one can interfere with that. No one can take that away. Until the day you're called home, you will be able to develop your own conscience and your own person. But the Second Amendment, you have the right to bear arms, right? Right to bear arms. So it becomes a right after the First Amendment. First are all freedom, second becomes all rights. So the intimate familial relationship with your child was found to exist under the First Amendment because you have the freedom to be a mother. You have the freedom to be a father, right? Because God made you a mother. God made you a father. And until the day you die and called home, you will remain a mother or father. Therefore, it must be protected as a freedom, not a right, because God made you that, not the state. Therefore, no state can take it away from you. So they said that it was found to be fundamental, protected under the First Amendment, right? Therefore, it is no different than any other enumerated right. However, it's not written, it's not enumerated. And that's where we needed the indictment issue to come in and take part. Because the Supreme Court came out in 2019 in a case called Timms versus Indiana. This was a unanimous decision by many of the same justices we have today, 6 of them in fact. And they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So I know that was a mouthful. Let me go ahead and tell you what that means, okay? So the privileges and immunities of United States citizens are at a minimum, those enumerated, meaning that those are written within the Bill of Rights, that's the first 10 amendments, given their legal effect from states interfering from them because they're written in the Constitution's text, okay? So if it's written in the first 10 amendments, that is at a minimum what every single person in America is guaranteed, no matter where they choose to reside within the jurisdictional United States. Problem is that right of intimate association isn't enumerated. Indictment is enumerated, right? So we can't come in under Timms versus Indiana, an existing Supreme Court precedent, and say, okay, we want to preserve the familial. We want to get these children back home to their mothers and fathers because it's guaranteed by the Constitution, because they're going to say, oh no, it's not enumerated, right? And if it's not enumerated, we don't have the same power. Then it doesn't become what's known as de novo, a pure question of law. Then it's that court would have to say, oh yes, we did find it to exist, or oh no, we don't find it there. We don't see it there. And that's what they would do on this case, because this case is big enough. The intimate association, the familial unit, and where we're heading and how much money they make off of these children every single year, there's no way that they would go any direction other than, oh no, we don't see it. It's not found to exist because it's not there. So we got to use an enumerated right, something that's written in the Constitution. That's why I'm using the indictment issue, because it's enumerated, because there's no denying it. The courts aren't even arguing it. And you guys, you know what? We have 42 states as of this moment, right now, that I've already served the United States or the state attorney general and the state Supreme Courts. I've already gone across this country numerous times now. We've served all of the agents, all of them. in all these states. We've given them ample time to be able to respond. Here in Minnesota, we served the second week in May, the Attorney General, and then we came back in the second week in August and served the Supreme Court. So we served the highest executive officer with an affidavit, a notice that his agents, the prosecutors, are committing crimes by following an inferior law that deprives a person of right guaranteed by the Constitution. We've given him almost a year to address it, and guess what? They're not even talking about it. They haven't changed a damn thing, right? Now that Attorney General, after me personally serving him, Elliot, he is knowingly and willingly engaging in criminal behavior to undermine the laws of the United States after swearing by oath or affirmation that he would do so. And that, unfortunately, for him is the crime of treason, right? He's going to have to make a decision very, very quickly which side of law he wants to be on, but I think he's already made that decision, right? So once we gave the attorney generals, after serving 42 of them, personally, I personally drove around the country and I served them. Then we came back and we did another trip around the country. And we served all the state Supreme Courts, because guess what? The Supreme Court is in charge of all the judges. So we had to get the highest judicial officer informed of these crimes as well. So once we didn't get action or correction of the unlawful acts by the attorney generals to correct their behavior, then we went back and we served all the state Supreme Courts, right, through their agents. And we gave them an opportunity to be able to address it. Guess what? They didn't change either. We didn't expect them to, guys. I didn't expect because the Saint Augusta Assisi said that how incredibly alike are all the tyrants, but how gloriously different are each of the saints. Tyrants are all exactly the same. Yes.
Did you say you served who? It wasn't Abler?
No, it was Elliot.
Elliot. Oh,
Yeah.
okay. I had it wrong. Okay.
Yeah, yeah. And I don't remember who my applicant was here. It was
It was
Jamie.
somebody I really upset. I saw the video, right?
Yeah,
And he
yeah.
was like-
So that was a deputy attorney general that actually served. It wasn't Elliot himself, but it was his deputy. So yeah, here in Minnesota was one of my favorite videos. Minnesota, Idaho, and I think Ohio. Those are my three favorite. Ohio, the assistant or the deputy attorney general came out to receive the paperwork, and it's really hard to get with these people, because once they know that they're getting served, they don't come around. They lock their doors. I'm having to hide in elevators waiting for them to come out. I mean, it's nuts. But in Ohio, I looked the part. They thought I was a U.S. attorney. I said, I have evidence here in ongoing federal litigation. I need to drop it off. I need to, but we need to make sure that I drop it off with I'm an evidence custodian. We need to make sure we drop it off with another evidence custodian. I need to have an assistant attorney general. They said, oh, great. We'll send you. They sent me up to the attorney general's floor. I went right to his door. And the same thing happened with the United States Attorney General Garland when I served him last April 9th. With the same paperwork, I just went in, and you're not supposed to go in Department of Justice at all. Like, unless you have a contact or an invite, you're not supposed to get in. And I have evidence here on ongoing federal litigation. I need to drop it off with the Attorney General. They're like, okay. And they sent the chief of staff down to get the paperwork from me. But then when the chief of staff's there, he's like, well, how'd you get in this building? And it was around that time that I said, well, I'm sorry, sir, but you've been served. And I got out of that building as quickly as I could, and I tailed it down 2 blocks away to the bus stop, because and that was the beginning of the service. I served the United States Attorney General on April 9th first, before I went around and started serving all the states. So we started with the United States Attorney General, and then we went through and we served all the state attorney generals, and then we went back and we served all the Supreme Court justice. So the reason why all tyrants are the same is because the tyrant teaches the other tyrants how to do stuff, right? So, when you come into a job, you're taught how to do that job, right? And when you're taught how to do that job, the way you learn to do it is the way you do it. So once we can identify the procedural situation, the way that they do their business at the low level, we know that that's how they're doing it at the high level, right? So the only reason why these state judges are able to break the law, how they're able to commit these crimes, is because their boss, the United States Supreme Court, is leading them to do it and permitting them to do it. They were taught to do it a certain way. That's why we got to start with the top. We got to say, listen, you guys are the criminals, because you guys are permitting this criminality to exist, right? And so we didn't expect to see change because you got to start at the top. Just like I said, you fight crime from the top down. So we got to go to the top. We got to get to the Supreme Court to acknowledge the criminality that they're committing because of the despicable rulings that their predecessors put into place, people that unfortunately owned slaves themselves. And then we wonder why the slavery institution exists here in America. And I'm going to hit that a little bit more here. But the Supreme Court of the United States, of the first 28 justices that served on that court, 22 of them owned slaves. Owned slaves. Now, unfortunately, the Constitution of the United States was designed to set people free, right? It was designed. Those are the laws that set free. So the laws that set free are being ran by slave owners. They didn't want the Constitution to be successful. And so the court immediately started undermining the Constitution of the United States by putting into place judge-made rulings which removed the fundamental rights of the people and in putting in its place judge-made rulings that they called case law. So if you guys are familiar with case law is what judges say that they produce. But case law is an oxymoron because judges can't create law. Judges cannot legislate from the bench. They must create rulings, but their rulings must be consistent with the positive law that the people create because judges are tethered to that positive law. If not, then that means that judges create the law, not the people. And that's the world we live in today. So this indictment issue in particular, it was 1887, United States Supreme Court under the Waite Court. They came out because the state of California said, we don't like indictments. We don't like grand juries. We want to be able to enslave and imprison people a lot easier, right? And so they created what was called information. They said, we're now going to charge people by information, not by indictment. Indictment is, it goes in front of a neutral, unbiased 16 to 23 people who will review the state's case to determine whether or not there's probable cause to assume that a crime has been committed. And that means that it's not the judge making the decision. It means it's not the prosecutor making the decision. It means that you must present your evidence of this criminal allegation to 16 to 23 people who are say, no, you're going to charge, this and not whatever the prosecutor wants to charge in order to create threats, intimidation, whatever, to force them to do what they want. So it's a check on prosecutorial power. And so what happened was that information, it doesn't go to 1623 neutral, unbiased people that are not a part of the state. It goes instead to the judge. And the judge, unfortunately, works for the same entity that the prosecutor works for, the same entity that law enforcement works for, the same entity that CPS works for. They all work for the state. They all work for the state. And so the body of men that make up the state, when the state brings an accusation against you, that same body of men cannot be the judge against you. Which is why the Constitution says in Article 3, where it's at, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Because no state can be judge and party in the same cause. And this is very, very well documented, not just in the Constitution, but also by James Madison. James Madison is considered the father of the Constitution. He wrote it in the convention, the Constitutional Convention. He is the one that personally drafted the entire Bill of Rights. It wasn't Thomas Jefferson. Thomas Jefferson was in France at the time. It was James Madison that wrote the Constitution. And in fact, Justice Gorsuch, United States Supreme Court right now, he says that James Madison is the only authority on the Constitution. So if we want to know why the Constitution says what it says, well, let's see what James Madison has to say about it. So James Madison wrote what's called the Federalist Papers, right? And when we were trying to adopt the Constitution of the United States back in 1787 and move from what we were previously a confederacy to a union, then the Federalist Papers were written. But they were written, and it was a whole bunch of newspaper articles, right? And they were trying to just convince the country, particularly New York, to adopt the Constitution because New York was a little bit reluctant. And so they were writing these newspaper articles and putting them out there to try to explain why the Union is necessary and why the Constitution is the way to go. Because if we didn't get it ratified by the states, it would have never happened. So James Madison wrote the Constitution. He wrote the Federalist Number 10, and in the Federalist Number 10, James Madison said, no man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So a body of men are unfit to be both judge and party at the same time. So when CPS brings an accusation against you, that judge cannot be judge in that case. That judge must recuse himself because he works for the same body of men that the plaintiff does. And don't kid yourself, CPS is absolutely an agent of the state because they're enforcing the laws of the state. That makes them an agent of the state. So if CPS brings an accusation against you, that judge has no authority to be on that bench because Article 3, Section 2 says in all cases which state shall be party, Supreme Court shall have original jurisdiction. Because James Madison said that a body of men are unfit to be both judge and party at the same time. And another founding father who wrote the Federalist Papers as well, because there were 3 founding fathers that wrote the Federalist Papers. Another one was named Alexander Hamilton. And in the case, Alexander Hamilton wrote in the Federalist number 80, he wrote 2 very, very important points here. One is he says that the federal judicial authority of the Union, meaning the federal court, right, federal judicial authority, must extend to all cases between state and the citizens thereof. If there's a dispute between the state and the agents of the state and a citizen of that state, the state can't be judged because no man can be judged in his own case, right? If the CPS is bringing an accusation against you on behalf of the state can't be the judge and be presumed to be neutral and biased in that position. Therefore, our founding fathers said the federal judicial authority of the Union must extend. He also wrote in the Federalist number 80, he says state tribunals cannot be presumed to be neutral and biased when they speak for themselves. No man ought certainly be judged in any case with which he has the least bit bias or interest. State tribunals cannot be presumed to be neutral and unbiased when they speak for themselves. Therefore, in all cases which a state shall be party, Supreme Court shall have original jurisdiction. Pretty clear, right? 2 of our founding fathers, 2 of the authors of the Federalist Papers, the records that we have from them of the original intent and purpose of the Constitution written right here. But you know what? There was a 3rd author of the Constitution. His name was John Jay. And John Jay was the first Supreme Court justice of our country. And John Jay didn't write in the Federalist Papers, but he did in a case called Martin versus Hunter's Lessee from 1811. And what John Jay, Chief Justice John Jay said is he said, the Constitution has presumed that state attachments, state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. It is the case and not the court. Therefore, if your case is state of whatever versus you, like your son's case, state of Minnesota versus your son, state is a party. There's only 2 parties in every case, and it is the case and not the court that grants jurisdiction to the Supreme Court. Therefore, if the case is state of Minnesota versus your son, that case is determined that in all cases in which a state shall be party, the Supreme Court has original jurisdiction. It's the case and not the court that grants jurisdiction to them. So when you have a case that says state of whatever, child protective services, it is a state that's named a party. And as a result, that state has no authority to be able to do the things they're doing. The Constitution was designed to create limits of power, and in some cases, states' powers are limited. In other cases, federal powers are limited, and in more cases, both powers are limited, but they're limited in order to preserve the individual liberties of the people. So if you have the right to have an intimate familial relationship with your child without governmental interference, and the state decides that they're going to interfere with that right, then the state has no authority to be able to oversee that dispute because the same body of men doing the accusing cannot be the same body of men doing the judging. And this is very, very simple. So states cannot create their own laws, substitute them for the guarantees of the Constitution of the United States of America, and then go out and enforce them in violation of the Constitution. Okay? So if you have the right to have an intimate relationship with your child, was it a son or a daughter?
My 2 daughters.
Your 2 daughters. I'm very sorry that this country has failed you like that. We're going to get him back home to you, okay?
Thank you.
I promise you, I give you my word, and I'm a man of my word. But we're going to get him back because you had the right protected by the Constitution of the United States. The Constitution was designed to protect you from governmental overreach. The purpose of our government was not to destroy families. The purpose of our government was not to lock people up and force them into involuntary servitude in a for-profit business for the direct benefit of the state. The purpose of our government was to preserve the rights not given up in our social compact: life, liberty, and an environment that we can find happiness in. Okay? Can you find happiness right now?
No, they
No.
destroyed it.
No, because our government has decided to abuse the power that they have been given in order to interfere with your familial unit, which is causing you to no longer be able to find your happiness. And yet that was one of the sole purposes in the establishment of this government. Government shouldn't be going for the last resort first. They should be looking at ways in which we can preserve the family instead of destroy the family. But they're doing this because they're making a lot of money off of it.
I know.
They're making a lot of money. Every child they take from the loving care of the family. You know, right now, today, we're talking about the Title 4D funding. And we're thinking, oh, well, look at all the money that they get from the Social Security Administration because when they took your child, they got grant money. Hundreds of thousands of dollars from the federal government for every child that they... So, you know, they've gotten, whatever, $600,000 for your 2 children that they just took under federal funding, Title 40 funding to do that. And everybody's talking about that as money. And what I got to say is that doesn't compare at all to the long-term money that they're going to get from your 2 daughters who are not going to have the love that they need and the image of self that they need to be able to know who they are and to be a part of society, because the love that they needed and the image of self came from their mother, who was taken from them, right? And their father was taken from them. So as a result, these children are now going to grow up and not be able to be a part of society because they don't know how to be a person, because their image. So that's why these children have got an 80% likelihood of going to prison over their lifetime, because they don't have the knowledge of love that they need. This is extremely well known. When you look at what God created in the familial unit, it's a very has a very specific function, and it's very important that we all understand this, because you know the greatest treasure of America is not the money, it is our children, because that's the only thing that's going to last after we're gone. So we've got to protect that, right? The money, it goes away, it doesn't even have any value. But the familial unit, mother and father are extremely important. A father, let me start with that, because I know that one really well. For a father, I give myself to my son. I give my image to him. He learns how to be a man from me, right? So he learns how to be a man from his father because I pass myself on to him. He learns how to do that. Absent a father, it's very well known, read the DSM, when you remove a father, that male child has a lack of sense of self. He's highly suicidal because he doesn't know how to be a man, because his sense of self was taken away. This is very well known in psychology. So when you remove the father from the child, the male child has no sense of self, right? Now for the daughters, my daughters, they learn how valuable they are from me, because my daughter's first love is me. Right? They're going to learn how to be loved and how precious and valuable they are because I'm going to teach them that. So absent a father, those daughters are not able to build long-lasting relationships because they don't understand how valuable they are, how important they are, how precious they are, and therefore they're not able to build relationships. And so now we see the breakdown of the relationship absent the father. Now the same can be said on the mother. Exact same thing. Because that mother, she gives herself to her daughter. Her daughter learns how to be a woman because of the mother. Absent the mother, now you have a daughter that has no sense of self. She has a great likelihood of committing suicide. She doesn't adjust because she doesn't know how to be a woman, because her image of woman was taken away. All very well known as well, directly out of DSM. For the son, his first love is his mother. That's why a son will marry someone just like his mother, because he learns how to love from her. Just like a daughter will marry someone like her father because she learns how to love from him. So absent these things, absent this familial unit, with the breakdown and destruction of familial unit that we see across this country, we can expect to see this breakdown with all of us. And so this is what's happening. And we're doing this so we can profit off of these acts. So we get traded on the New York Stock Exchange in the form of Geo Group and Core Civic and CCNA, these for-profit, privately traded companies on the New York Stock Exchange that build, manage, and operate prisons for state and federal institutions.
And I think when they have disability, it's a whole different level, because they get paid a lot more. And so they're actually trying to transform these children into having disabilities so that they can get the funding for the disability as well, so they're pushing medication.
So I'd love to answer some questions. If you guys got some questions, I'd love. So where we're at right now is these affidavits. So let me just run through the affidavits real quick, because CJ, right? Nice to meet you. All right. Okay, so we have one indictment, 2 indictments, and the rest are families. Okay, so, all right, so I'm going to do the indictment first because the indictment is very easy because it's all written right here, okay? So, again, the Constitution of the United States is the supreme law of the land. Provides the overarching requirements that all states must follow. So when a state chooses to enact its own alternative legislation and substitutes it for the guarantees of the Constitution, that is called sedition. Because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. So if you attempt to alter the Constitution in an other than lawful manner, that is the very definition of sedition. So when a state who has no authority to amend the Constitution through typical state legislation, that would be an act of sedition. States cannot change the Constitution and the procedures and processes because they're subject to the Constitution, right? So when they do enact a law, right, that prosecuting attorney is choosing to rely upon that inferior state statute to charge improperly, despite the fact that they have an obligation to obey the Constitution of the United States of America. So the prosecutor, what they're doing is that they have a duty and obligation to ensure that the power that they exercise is consistent with their authority. And their authority comes from the Constitution of the United States. So when they choose to rely upon a law that is seditious, or a law that's unconstitutional, or a law that's not valid or inferior, and they rely upon it to abridge someone's constitutional rights or to take them away, then that would be a crime. It's called deprivation of rights under color of law. Title 18, subsection 242. And what 242 says, it says any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution, commits that crime. This is a per se crime, which means that I don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge derives from the promise that they make. When you take an oath and you say that you will do what the Constitution of the United States says that you will do, and you fail to do it, you have already implicitly invited punishment in the form of perjury should you fail to fulfill that promise. You're already guilty. That's why it's per se. So per se crimes mean that there is no finding of facts. There's no trial that's done. There's no jury. All I got to do is show you had an obligation. It's written right here. You didn't do it, and as a result, you are now guilty because there's no right to self-defense for public officials for their criminal conduct. That's what per se means, right? So another way of looking at it is when you read per se and you actually look it up in Black's Law Dictionary, it says that per se crimes are self-evident, which is a very interesting word because we find that same word in the Declaration of Independence. We hold these truths to be self-evident, and a lot of people don't understand or realize that a self-evident truth is the truth that's written right here in the Constitution. That's self-evident. That's what makes it per se. Because I can read this and I can see by my own self-evidence that you're guilty of a crime, a very serious crime, right? So the public officials, they don't have the authority to promise to do what the Constitution says that they must do and then go out and do something different. They don't have the authority to do that. So when a prosecutor chooses to rely upon an inferior state statute that allows them to deprive a person of right guaranteed by the Constitution of the United States of America, they just committed that crime, deprivation of rights under color of law. When they bring that order to a judge and they say to the judge, I'd like you to hold this person over for this offense, this felony. That judge also has a duty and responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse power, who relied upon the inferior state statute to deprive a person of right guaranteed by the Constitution of the United States of America, that judge is also now depriving of rights due to his negligence, and he has now established a conspiracy to deprive rights by and between himself and the prosecuting attorney. That's Title 18, subsection 241. 241 says, when 2 or more persons conspire for the purpose of depriving any person of any rights given by the Constitution, commits that crime. So now we have a conspiracy by and between the judge and the prosecutor to deprive of rights. When that judge signs that order, directing an officer to go out and perform an arrest, without having the proper charging instrument in place. That officer also has a duty and responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the judge's abuse of power, who relied upon the prosecutor's abuse of power, who relied upon the inferior state statute to deprive a person of right guaranteed by the Constitution of the United States of America, that means that officer is also now depriving of rights under common law because of his negligence. And when he goes out and performs an arrest as a part of the criminal conspiracy, the moment he performs that arrest without having the proper authority to do so and the proper documentation, he's now committing a crime of kidnapping. And it is a federal kidnapping offense 1201 because they're holding the victim over for ransom in the form of bail. And anytime you have ransom involved in a kidnapping, it is always, always, always a federal offense. And anytime that you have a deprivation of rights under Colorado law, crime that occurs in conjunction with kidnapping, the punishment as prescribed by law is death, Supreme Court. It's death. So read about it. Look it up, guys. So we have a very, very serious offense that's very simple to show. Very simple. Constitution says you had to do it. You didn't do it. And why didn't you do it? Because you believe that a state has the power to abridge and violate the Constitution of the United States of America. You believe that states have the authority to be able to break down and destroy the one thing that the people of the United States believe in. And I'm telling you right now, public officials, don't go that direction with us. Don't go that way, because I got 330 million people standing behind me. You got less than 1 million standing behind you. Who's going to win this fucking battle? Sorry. Let's do the familial unit now. So for the family, we've gone through it. We've shown there's a right to have an intimate familial relationship. You have a right to have a relationship with your child. God made you a mother. God made you a mother. If God doesn't want you to be a mother or father, God can take care of that. It's not a creation of the state. So the same thing exists here, although it's not enumerated. It's not written. It was incorporated. Supreme Court of the United States, 1984, incorporated it in through a judicial ruling. We can all read the ruling. 1984, Roberts versus United States. It's written on those affidavits right there. That's the case that you guys... That case, the United States Supreme Court said you have the right to have an intimate familial relationship with your child without governmental interference. So when an agent of the state, in this case CPS, when CPS chooses to rely upon that inferior state statute that is in violation of the Constitution of the United States of America, when they choose to rely upon that inferior state statute that permits them to go out and interfere with your familial unit, your relationship with your child, that prosecutor, that CPS, whoever that law enforcement, whoever that might be, they have a duty and responsibility to make sure the power they exercise is consistent with their authority. If they choose to exercise their power based upon the inferior state statute that deprives you of your right, already incorporated by the Constitution of the United States of America, they just committed the crime of deprivation of rights under Colorado law. Same way as the indictment. When they bring that to a judge and they say to the judge, I'd like you to take this child away. I'd like you to terminate the parental rights right here. That judge has a duty and responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the CPS's abuse of power, who decided that they could interfere with your familial unit without lawful authority in violation of the fundamental rights that you're guaranteed to have, that judge is also now depriving you of rights guaranteed by the Constitution of the United States, Title 18, subsection 242, and he's also now established conspiracy by and between himself and the CPS agent or the whoever that might be, right? And then when he signs that order, it says, "Yep, take the child away and let's go and adopt him out," right? Or whatever it might be. That officer, because there's always going to be an officer involved. Remember, CPS is enforcing the laws of the state. Therefore, they are operating under the highest law enforcement officer so they're operating under the authority of the prosecuting attorney. That's why if you don't know who the officer is, because one of the questions down there in filling it out, one of the questions is the officer. If you don't know the officer, then you're going to put prosecuting attorney. Because whoever it was that took your child was operating under the authority of the highest law enforcement officer of the county. So it doesn't matter who it is. What they're doing is under the authority of the law enforcement officer. So CPS is enforcing the laws of the state. Now, another thing. So with these affidavits, right? These affidavits are very, very, very particular, right? The ones for the familial unit, 22 pieces of information. I don't want any more information. I don't want any information taken away. They need to be exact same. And it's very important that they're that way, because in order for me to litigate this in a group, right? In order for me to litigate on behalf of 12 million children that are currently robbed from their families and 24 million parents who have had their children robbed from them, in order for me to litigate on their behalf, I need to bring everybody into the same procedural situation, right? Because if I can overcome one petitioner's procedural situation, I can overcome all of them. It's called vicarious relief. That's why we're doing the affidavits in this way, bringing everybody into the same procedural situation so that I can litigate everyone all at once, right? And so anytime that you have a class action habeas corpus, which is the mechanism that we're using, that's what we're using to bring to court. We're using a class action habeas corpus because a habeas corpus is if your rights have been taken from you, any fundamental right has been taken from you by a state without lawful authority, you would use a habeas corpus as a judicial relief to restore the liberties that have been taken, okay? There's nothing to appeal because if the court doesn't have the authority to take your child, then that means that once again, when they took your child, right? When they took your child without lawful authority, the moment they took your child, that was in violation of the Constitution, which means that everything that happens after that is unconstitutional. So the TPR that they did, the termination of parental rights that they did, a year later, that is not, it doesn't even exist because it derives from the unconstitutional act of the interference with your familial unit. The moment that they interfered with your familial unit, as of that moment, everything after that is void, doesn't exist. It's ab initio, and as a result, you don't have to go to the end and appeal anything. That's what the attorneys are all wanting you to do. But we're going to go to the beginning, and we're going to say the moment that you broke the law and interfered with the familial unit and the preservation of that familial, the moment you did that, everything after that is unconstitutional. I got someone behind me here, and sorry guys, I don't know what's going on. So on the video here. All right, so if you've been told that you can't appeal, your judgment, like let's say that there's already been a TPR that's been put in place. So let's say that there's already been a TPR that's been done, a termination of parental rights, and everybody's telling you there's nothing you can do. It's over, right? It's not over because the court didn't have the authority to do that because that derived from the original unconstitutional act of interfering with your familial unit. So one of the things I like to say is that a lot of us we want to defend ourselves, but you don't want to defend yourself anymore. Because when you're playing sports, right? When you're playing football, the best position strategically to be on is offense, right? Because you're going to score. Best position is on defense. So what you guys are doing when you're appealing is you're defending yourself. You're on defense. And if you're defending yourself, that puts the government on the offense. It puts them into the better strategic position. So we need to flip the tables here. And the way you flip the tables here is you go on offense now. And you accuse them of the crime that they committed against you. And you don't have to talk about anything after that. Because if you can show that they committed a crime the moment that they interfered with your familial unit and the relationship with your child, that's a crime. I think I clarified, that's a crime the moment they did that, which means that you don't have to defend yourself anymore. You have to accuse them of the crime they committed against you. And when you stop talking about the things that they've done to you, and you start talking about the things that the crime that they committed, then as of that moment, the tables have switched. You're on offense. You're now moving, and they can't win in offense or in defense because there's no right to self-defense for public officials. If they broke the Constitution, if they broke the law, what they produce after that is always going to be unlawful, period, right? So these affidavits that you have here, they're all exactly the same. And the reason why I'm saying don't put a prosecutor in the name, because you'll see, I don't want a name of a CPS agent. I don't want a name of a judge. Because if we call them out as a judge there, well, that's their official capacity. There isn't a judge there if the court didn't have the authority to do it. That's why it says a person portraying themselves as a judicial officer, because that's them in their private capacity. That's them pretending to be something that they can't be because the court didn't have the authority to do anything because it's in violation of the Constitution. So we don't want to call them out in their official capacity. We want to call them out in their private capacity. Because in calling them out in their private capacity, we say, this person was pretending to be a judge. This person was pretending to be a law enforcement. This person was pretending to be a CPS agent. But they couldn't be if they're acting in violation of the Constitution. So we're going to call them out in their private capacity, not their public capacity. You call them out in their public capacity, and now we've got immunity issues and all kinds of other stuff. We're not doing that, okay? And I don't want case numbers on here Because the difference between a criminal affidavit and a criminal complaint is a criminal affidavit, what you guys are filling out right here, you guys are witnesses and victims of a crime that has actually been committed. And the affidavit is an affidavit of truth that this crime was committed, right? And so as a result, the criminal affidavit is you guys' verified statement that a crime has been committed against me. And then from there, I'm taking this as the evidence custodian. I'm taking it into my custody, right? That's what these bins are for. We're taking it into my custody, and I'm going to personally maintain the custody of this evidence between here and Washington, D.C., where we will deliver it into the judicial proceeding to decide how do you want to address these crimes that have been committed by these actual victims. Now, remember, if you were to call up the police and say to the police, this crime has happened to me, that police officer would take your information and reduce it into an affidavit, right? And that's what they submit to a prosecuting attorney to start the criminal process, which is known as a criminal complaint, right? So the affidavit is the first step. But the problem is that the Constitution says no warrants shall be issued but upon probable cause supported by oath or affirmation. When the officer presents the information under his oath, he wasn't even a witness to it. He's just simply taking information from someone else. And he's delivering it to the court as though it's factual, truthful, and correct under his oath. We don't know. That's actually a violation of the Fourth Amendment. What I'm doing is I'm saying, you guys are victims. I might be the evidence custodian, the law enforcement entity right now that's moving forward with this work. But you guys are the victims. Therefore, you guys have to sign these, just like the officer should. Yes.
So, I mean, did I do it right then that the police department that held my son in that medical kidnapping, I will put that police department, or are we?
That police department. Yeah. I mean,
I didn't know if I did it right or not, so I would actually put that.
yeah, I would say a person portraying themselves. You see what the.
I don't know the name, I can't.
Yeah. So.
But you said don't get.
Yeah, I don't want to. One thing is like, I know you guys. I know that there's a whole bunch more people were involved in these, right? I know that it wasn't just an officer, a prosecutor, and a judge. I know that there's so much more that could go into this, right? And you want to put so much more into this, but that takes you outside of the standard procedural situation. What I do know, the material fact, what we need to give to the criminal person, to what we need to give to the court and say, what do you want to do, so that everybody's the exact same, is that there was a judge, there was an agent portraying themselves as CPS or a state agent, and there was some law enforcement entity. There could be all kinds more, but there has to be all three of those in every single instance, because the CPS can't take the child without law enforcement. Law enforcement has to be a part of it. Now, whether law enforcement is present is not necessarily relevant. That CPS can't do it without the authority of the law enforcement. So if there wasn't a law enforcement officer that was there and it was just CPS, then the law enforcement officer that you'd identify would be the prosecuting attorney, because they're operating under the authority of the prosecuting attorney. That CPS can't do anything without the prosecutor of the county authorizing it. They can't take that child without the prosecutor. Therefore, they're operating under the authority of it. Yes?
What if they were to have gone to another county and taken the child with force, while you weren't there during his hosting station, without any warrants or prosecuting attorneys, just based on the agreement you signed? The baby wasn't living at, you and the baby weren't living at the address that they put on the agreement, but they had no proof that I wasn't living there. It was just my baby was being watched by my uncle and auntie or whatever during while I was out of town for I left them during the evening.
Yeah. Yeah.
I returned. Not the next evening, but the morning after.
Yeah. So the material fact is.
There's no warrant or anything, or judge.
But the issue isn't the warrant. The warrant is coming after the interference. So you weren't here for the first part. No state can it's okay. No, it's all right. I just want to explain that no state can interfere with your relationship with your child. God made you a mother, not the state. That child is not a creation of the state. It's a creation of God. God made you a mother. Therefore, only God can take away your motherhood. That's why the Constitution of the United States protects that. Now, the warrant comes after someone interfered with your relationship with your child. The material fact that we're trying to identify here and get everybody in the same procedural situation is the material fact that you had a right to have a relationship with your child without governmental interference, and the state interfered with that. And we don't have to talk about anything after that, because if I can bring everybody back to that point, because 12 million children are currently, over 12 million, currently sitting in the CPS system across this country right now today. 12 million children. Every single one of those children had the right to have a relationship with their family without governmental interference. That's what the Constitution protects. Therefore, every single one of them had that right interfered with. And that's the material fact that we want to come. That's the point that we want to go to so that we can litigate everything together. Because if we start talking about rules of evidentiary procedure, or we start talking about lies of CPS or bias of judges, all of that is after the material fact that you had the right to have a relationship with your child and they didn't have the right to interfere with it. That's the moment that the Constitution is violated. And that's the moment we want to focus on. And that's why we're trying to bring everybody in the same procedural situation. Same thing with these indictments, you guys. Same thing with the indictments. Because we don't want to talk about the plea bargain. We don't want to talk about the trial. We don't want to talk about evidence. We don't want to talk about lies of judges or bullshit from judges. We want to talk about the moment that you were arrested and held to answer for an infamous crime without the proper documentation. Because if we bring all of you to that exact moment and that exact point right there, we have 70 million litigants. Because there's been 70 million people that have been charged with or convicted of a crime here in the United States of America, and every single one of them can be, 1/3 of our country has been illegally and unconstitutionally charged with a crime. Now, if all 70 million of those people start talking about the moment that they were held to answer without lawful authority and nothing else, we'll be done in 40 days. I'll go back to DC and they'll be begging for me to come and argue this because 1/3 of our country talking about the Supreme Court of the United States committing a crime, judges across the country committing. That's why we win with the power of numbers. A lot of people say, "Oh, this will never happen. It's too big." Too big is not an indication of weakness. Too big is an indication of power, right? Because power isn't the badge, it isn't the gun, it isn't a money. Power is the ability to influence others in their future decisions. Power comes from our words. And when we get 70 million people talking about one crime being committed by every single judge across this country, you want to talk about power? There's our power. There's our power. Power comes with numbers. That's why we had to build. That's why I had to go and serve the attorney generals. I had to serve the Supreme Courts. Lots of people don't like me, but you know what? It's done. I've done this under the radar, and just I don't know if any of you know. I don't get paid for what I do. I don't ask. I don't take on contracts. I won't work for money. I don't speak for anyone. I speak for everyone. This is not an easy life to live, but I do this because someone has to do this. So love me or hate me, believe in me or not, I'm out here doing this because someone has to do it, right? Because those 2.9 million people that are currently in prison right now today, they don't have any money. They can't hire someone to go and do the things I'm doing. So someone has to do this. And whether people like me or not, I don't care. I know exactly why I'm doing this. And I know exactly who I'm doing this for, right? And he's empowered me to do it. And so there was a question earlier about concern about getting involved in this because of potential retaliation that might occur. So I totally understand that. I get that. And every single person is going to have to individually take a look at this and say, okay, do I want to be a part of this? Do I want to put my name out there? Because it is true. We are dealing with the most powerful narcissist known to mankind right now, right? And her name's Justice, and she's a bitch. And she's led by a bunch of narcissists because every one of these judges are nothing more than narcissists. They're all liars. They all have an illusion of power and strength. They're all projecting onto you the very thing that bothers them. They call you a liar. They call you a criminal. They call you delusional when they're living in a delusional world themselves, right? Because that's what liars do. They have to construct a lie to protect the other lie. And so eventually they start living in a world that's nothing but a bunch of lies. And then they call you crazy because they're living in a crazy world. No, what they're doing is they're projecting. Narcissists project. And they project because they don't want the mask dropped. They don't want people to look at them. So they call you what they are because that gets the attention off of them. Guys, this is simple narcissism, but that's what they're doing. So what we have to do is we have to reflect back to them exactly what they are, right? That's why you defeat the narcissist. There's no introspection. So we're dealing with these people that do not want this mask job. They don't want to be exposed for what they really are. They're a bunch of criminals. And yet they're calling all of you criminals, right? That's because deep down inside, they know inherently that they are a criminal. It's projecting, right? It's a narcissist. It's a liar. This is how they function. And so once you understand that that's what they're doing, then you can kind of understand how to attack them and how to come back. So we're dealing with narcissists. We're dealing with people that don't want to be exposed as the frauds that they are. And as a result, we need to just tell them the truth. That's the easiest way to do it. But anyway, so someone was talking about being a part of this, right? And the potential ramifications. The one thing I would say is that there is a spreadsheet that's on my Facebook page. And I know a lot of people don't like Facebook. I'm going to get it out on the website. I reached out to Joe earlier today, and we're going to get out on the website and make some changes because there's apparently some issues with downloading the affidavits as well.
5 and p.m. Central Library will be closed in 15 minutes.
Oh shit. Okay.
If you have materials to check out, please do so now by bringing it to the checkout station. If you're planning to bring
Tell them we'll be ready.
computers will probably shut off in 15 minutes. Thank you.
So on my Facebook site, there is a spreadsheet. It's got 10 questions. The 10 questions aren't so important. It's the last 2 questions that's the most important. The second to last question is, have you or someone you know been a victim of a crime committed by an agent of government? Okay. That particular question, what it does is it establishes you as a victim, right? A victim of a crime by an agent of government. The last question is, would you be willing to testify on behalf of the defendant at the Supreme Court with regard to the crimes committed against you or your family member with regard to the crimes committed against you, right? What that does is that establishes you as a witness. Now, just because you say that you're willing to testify doesn't mean you're going to testify, right? But if you identify yourself as a victim and you say that you're willing to testify, then what happens is now you're protected under witness tampering and intimidation laws. So if an agent of the state, any one of the states that I'm in active litigation against, once you're identified as a victim of the offenses that I'm attempting to litigate here, once you're willing and identified yourself as willing to be a witness under this case, once you do that, I can protect you under the witness tampering laws, intimidation laws, and if any agent of any state of the 42 states that we've served and that we're in active litigation, if any one of those agents attempt to intimidate, if you believe that they are acting in any sort of violence or aggression toward you, and it has to do with the fact that you're a witness on ongoing federal litigation at the United States Supreme Court, I get to file summary judgment to the Supreme Court, I get to file cease and desist, and I guarantee you that the Supreme Court will make that stop. I have a national do not detain, right? No state can arrest me, and this has been tested a few times now, where they've been pulled over a few times, but the states are not supposed to arrest me unless there's a specific crime and it occurs in their presence. I have a national do not detain. The reason why is because the last thing that the Supreme Court of the United States wants is an agent of the state acting in an aggressive manner toward me without lawful authority on a case that has to do with states agents acting in an aggressive manner without lawful authority. All right? So there is a lot of power that exists right now because these states, they are subject to Supreme Court. And if the Supreme Court is scared of the case because of the amount of money that they could lose from it, then guess what? They're going to tell these people to back off. And we even saw this in a case 2 years ago in Oklahoma. It was called McGirt, right? In the case of McGirt, they shut down the state of Oklahoma Oklahoma did not prosecute a single person for almost 2 years because the Supreme Court of the United States was waiting to determine. That particular issue had to do with Native Americans and whether or not you can prosecute a Native American on non-tribal land, right? But nonetheless, the entire state of Oklahoma is tribal land. So no court proceeded with any criminal adjudication during that period of time when McGirt was making its way through the federal circuit because they didn't know what to do. So if you can shut down a state on a case waiting for the higher court to direct the lower court what to do, we can do it across country. And we're about to do that, all right? So thank you guys so much for coming out. I'm sorry that we didn't get any questions answered here, but these affidavits are extremely important. What you guys are doing is you guys are empowering me to be able to go and advocate on behalf of you and your family to restore the familial unit. And I am a man of my word. I always do what I say that I'll do. I don't care what anybody says. I'm not here to prove myself. Because if I did, then that would mean that I value someone else's opinion more than I value God's opinion, and that's just simply not the case. So I'm here to get a job done, and we're going to get it done. And the fact that I'm still out doing it after 9 years, after serving 42 state attorney generals, serving 42 state Supreme Courts, and I'm still sitting here doing it. And we've got Mr. Trump that's going across the country that is doing the things that I'm asking him to do. I met with him 3 times. We're going to have them back in this. Right? Because I've sat down with governors, I've sat down with senators, I've sat down with congressmen. Every single one of them says that they believe in what I'm doing privately, but not publicly. And all that does is that tells me that I'm gonna have to get there by myself. But once I get there, it's not gonna be a fight because they all believe in it anyway. All right. So thank you guys so much for coming out tonight. Everybody over here, we're going to be doing this in every single city that we come to. So. Next stop, I believe, is going to be Bismarck, North Dakota, to get the state of North Carolina served. And then we're going to South Dakota to get South Dakota served. And then we're heading over to Montana to get those 3 served. That will be hopefully next week. But we're going to be coming through and circling back. And I really hope and I pray that we're going to have really good support and really good attendance in Texas. Texas, I want you guys to come out and start planning. We'll do Dallas, Houston, Austin, and San Antonio if we can get the attendance there. Love you guys so much. Thank you so much for being a part of this. And God bless. Have a great rest of your night, everybody.
You're making a difference.
Yeah.
You're making a difference here, because I had actually.
So on this time, you put the time to the attorney?
Yes, I think so.
Okay.
The shoes are people speaking out.
Agent and prosecutor.
She just
She might be on camera.
All right, guys. Thank you so much, TikTok. I'm signing off here. Thank you, guys. I'm gonna come through and we will I'll come through and read the questions here. Thank you guys so much for joining me. God bless. Have a great rest of your night, guys. Over here, YouTube. Thank you so much, YouTube. I'm gonna read the questions. I'll respond to them accordingly. Look forward to seeing you guys out in the field when we come to your city. God bless. And